the important third topic is principle of natural justice. This topic is very important. Why I am telling? Because certainly one or two questions come from principle of natural justice topic. So please learn it with curiosity. The terminology principle of natural justice is not alien terminology for us. We are very much aware of this terminology, principle of natural justice. Now we are just going to give some shape of the words for that. And what it says, natural justice is a principle that intends to ensure law with fairness and to secure justice. The very purpose of a principle of natural justice is to ensure the law with fairness and to secure justice. Rendering justice with fairness is the main motto of principle of natural justice. It is made to ensure that the decision making processes are transparent and impartial. Very important. Whatever decision making process is being done, both party or all party should be clear in mind that the system is transparent and it is impartial. Then only their faith will increase in the system. If any person who is not having faith in the system, today or tomorrow he is going to be out of the society. He will not like the system. So whatever decision making system is there, the person who is aggrieved or who is getting benefit, both should be feeling that the decision making process are transparent and impartial, and it is based upon the evidence. So when we come to know what are the principles of natural justice, initially there are two principles of natural justice. One is rule against bias and one is rule of fair hearing. Rule against bias has merged from Latin terminology nemo judex in causa sua. I will try to translate it into English. Nemo judex in causa sua. Nemo means no, judex means judge, causa means cause, sua means self. No person can be judged in his own cause. If a person is judged in his own cause, he will be biased, na? He may take decision in his favor. So from here, rule against bias originates. The second is rule of fair hearing. Fair hearing means audi alteram partem. Again, Latin terminology, we'll try to break out it. Audi alteram partem. Audi means to hear. Audio, we have terminology audio, visual. So this audi is from the audio. So to hear. Audi alteram means alternate and partem means party. To hear the other party. What happens when some allegation comes? Then one party comes with so many allegations. That allegations are right or wrong, it has to be decided later on. Whatever one person is telling, that blindly if I accept, it will go against the principle of natural justice. So any complaint is coming, any allegation is coming, just keep it and give chance to other person also to explain his views, his stand. And that is known as rule of fair hearing. Then only right decision we can expect. The third component comes is reasoned decision. Reasoned decision means speaking order. Whenever, I will give one example. Whenever you see some judgment copy, let it be the judgment copy of cat or court, first page generally comprises of the gist of the allegation, gist of the case, parties, court name, party's name, and gist of the allegation. This is almost the first page. Second page comes the trial process. Under trial process, what this person told, what this person told. what other person told. So all the evidence taken is enumerated in the second page or third page, and then on which evidence court relies, on which evidence court doesn't rely, that also to be mentioned, and then on bottom at the last decision is given, that on the basis of this reason this decision is taken. So that is called reasoned decision, speaking order. This order should speak the truth. Reasoned decision should state the reason on what basis decision is taken. Then only society will have respect for the law. So this is the reasoned decision, and in these two basic principles, nemo judex in causa sua, no one should be made a judge in his own cause. It is rule against the bias. And audi alteram partem, here the other party or no one should be condemned unheard. That is, this rule is known as rule of fair hearing. Now, this is 2, and third is reasoned decision. Fourth point is emerging, and that is very important point. Let us see. First one is no one can be condemned unheard, means rule of fair trial. This is the audi alteram partem. Let the other person be heard. Then no one can be judged in his own cause. This is the rule against the bias. Nemo judex causa sua. Then the D is final order must be a speaking order. So this is the reasoned decision. That C, justice should not only be done but should manifestly appear to have been done. That is most important. Whatever justice is done, whatever decision is taken, the party should have faith in the decision, and faith will come only and only when the system is transparent, when it is reliable, and when it is clearly visible that yes, this is the right or this is the wrong. So justice should not only be done but should manifestly appear to have been done. That is most important. Rule against bias we have seen. So it is a requirement of the principle that judge must be impartial, must decide the case objectively and on the basis of evidence. If judge is party in them, if the judge is interested in the case, then he cannot take proper decision. So he has to leave the case. So for that, to leaving the case, provision is there in the CRPC and CPC. If judge thinks that he is affected with the decision, if he is somewhere interested in the decision, then he is not supposed to be part of that case. So that is here. And then bias is coming. Bias is personal bias. It can be pecuniary bias. Personal bias means personal, person to person. It may be gender bias. It may be society bias. It may be religious bias. It may be age bias. Then pecuniary bias. Pecuniary bias means related to monetary. It may be related to monetary interest. And then subject matter bias. Many things. Some person likes sports, some person doesn't like sports. So it is a subject matter bias. So when we, every time when we refer the terminology bias, we must understand what is the meaning of bias. The meaning of bias is something preconceived opinion. Some opinion is already in the mind, and based upon that we are taking the decision. That is preconceived opinion, and that decision is not good as far as principle of natural justice is concerned. So personal bias we have seen, pecuniary bias we have seen, subject matter bias we have seen, departmental bias, most of us are affected by the departmental bias. Some persons are very near and dear, and some persons are not. Then preconceived notion bias. Yes, many times we have taken it granted that this is the thing and that is not the thing, and it affects the decision making process. And as far as obstinacy is concerned, many times it employs unreasonable and unwavering persistence of the decision making officer. Then next is coming rules for the fair hearing. Here the second important condition of natural justice is that the person whom an action is proposed to be taken should be given a reasonable opportunity to defend himself. Before passing an order against any person, he must be heard. That means he has to be given adequate chances to represent himself. He should be given chances to produce his evidence. He should be given chances, opportunity to rebut the evidences. He should be given the chances of cross-examination. So, in audi alteram partem, what we follow, even in administration also, or judicial also, what we follow? Know the charge. First of all, copy of charge will be provided to the alleged person. Then, alleged person has right to inspect the documents on the basis of which the allegations are leveled. Then he has right to know the evidence, who is going to give evidence and what are the evidences, so that he can prepare his defense also. Preparing of defense is most important. That is why knowing of charge, inspection of document and knowing of evidence is important. Then he has full right to cross-examination, and in judiciary we have seen cross-examination is very important part of the trial. And then lead evidences to prove his innocence or to make his point more emphatic, he will be given chance of giving the better evidences, to leave the evidences. So in this way, principle of natural justice is fulfilled. The question arises, if breach of principle of natural justice takes place, then what could be the outcome? So basically there are two principles of natural justice. One is bias and one is fair hearing. So if it is affected by bias, the aggrieved person is having right to claim. If he keeps mum, then it's voidable and the decision will stand. But as far as violation of the audi alteram partem rule is concerned, that decision, if it violated, it is completely void and it has no value. So what are the benefit of complying with the principle of natural justice? Principle of natural justice assists the decision maker with relevant information, evidence or interpretation of legislation or policy which she has not considered. It provides a useful venue for decision maker to ensure that facts or information is relying is correct. Decision maker with relevant information, evidence and interpretation of legislation then exposes the weaknesses of the decision making process information. Then the comments or submission made by the other person, organization may provide advance warning of the bias on which the decision is likely to be challenged. So these are the benefits of the principle of natural justice. Principle of natural justice is also known as basis of human rights. So we have to fight for our natural justice and we have to facilitate others natural justice also, because we are human being and we are expected to follow the rules of natural justice. As far as probation clearance exam is concerned, 10 marks question from this chapter is confirmed. If you can concentrate upon particular point and elaborate the things, very nice. Else, just sum up all the material and put up. It's always better to write something than leaving the question unattended. So please attend all questions. I hope everybody will get more than 40 marks out of 50 in administrative law. We'll meet in next class. Till then, namaskar.